Appeal in the matter of Kyle and Coventry City Council.
Yes, thank you, Mr. Abbey.
My lords, I appear with Mr. Cowan for the appellant in this appeal, and my learned friend Miss Rowlands appears for the respondent counsel. My lords, before I start my submissions, just one small matter of housekeeping. Unfortunately, our attempts to prune Part 7 of the Act so that only relevant parts were before your lordships was too radical, and therefore there was an additional small PDF sent yesterday, and then today we've also handed up section 188 of the
I haven't had the additional small PDF either.
We can.
No, it never reached our clerks. Who's it sent to?
Well, I don't know who it was
Okay.
sent to.
Well, it doesn't matter, but we'll cope. Have you got copies in court now?
Yes, we have.
Could we?
So-
Just while you're getting them, can I just deliver a little homily about this? I quite understand the thing about pruning, but actually, in this act more than anything, with the interconnection of different sections, the only safe thing is to give us the whole of Part 7 as it stands now, because you never know when it may be relevant to see how a phrase is used in some other bit.
Yes, my lord.
Also, we want them looking like this, not like internet printouts where it's all over the place, and really quite hard. I don't know who put the bundle together, may I ask. It tends to be done in chambers now.
Yes, my lord. It was done in chambers.
Well, I think clerks need to be. It's not their fault. They need. I mean, this isn't as easy to use, and each section is on a different page, and there's lots of notes and so on. So, could we have it in future PDF? The whole of the next time we're doing a Part 7 case, and I suspect the two of you in particular are always doing them in this court. The whole of Part 7 in this format rather than that format. And while I just get this off but I have no idea in what, according to what principle the authorities themselves are organised. The obvious thing would be chronological,
yes,
but they're not chronological.
No, I think they've been organised in terms of superiority of courts, House of Lords, Supreme Court, then Court of Appeal.
Not a sensible way of doing it.
No.
So, lessons be learned.
Yes, my lord.
Right.
I should know better, and my lord.
No, I'm not being personal about it. But again, in this area more than anything, seeing which case was decided, whatever level, what was the law then was this pre-alley or post-alley, and so on is crucial.
Yes, my lord,
okay, I've got all that off my chest. And are you going to be providing us the extra PDF that you sent last night?
My lord, what we shall do, if it assists, is at lunchtime we'll try to get you the entirety of Part 7 as in a manner that, as your lordship suggested.
I think that would be helpful. Perhaps somebody, Mr. Cowan, can be asking Chambers being on with that in the meantime.
Yes.
They could even perhaps bring it over in the course of the morning.
Yes.
Yeah.
Thank you.
Right. Off we go.
Right. Well, my lord, as you'll have seen, this is a second appeal against the Council's review decision of the 24th of August, which found that the appellant was intentionally homeless after being evicted from his hostel room, and Lord Justice Arnold granted permission to appeal. My lord, to start with, I think it's important that I set out the parameters of this appeal so that it is clear what this appeal is about and what it is not about. This appeal is about the concept of reasonable to continue to occupy. And it's the appellant's case that the council failed to direct itself correctly in accordance with Birmingham City Council and Alley. And had it done, it would have concluded that the appellant was not intentionally homeless. And secondly, and to some extent linked to that ground, is a reasons challenge, that the council failed to provide adequate reasons as to why the accommodation was reasonable for continued occupation.
If you're right, your first ground, I think, would no doubt become clear, is actually that as a matter of law, on the unchallenged facts,
Yes.
they were obliged to find that it was not reasonable to continue to occupy.
Yes.
In which case, reasons is really irrelevant. Reasons only becomes relevant if there was some factual or evaluative exercise they should have done, which is contrary to your primary case, as I understand it. In which case, if we ever get to your secondary alternative, I'd like to know what it was they were supposed to be evaluating.
So just very shortly, what they knew was that this room had been provided as Section 188 interim accommodation. They knew that it had a no visitors policy. They knew that it had restricted smoking rules. And they knew that the decision letter accepting the main housing duty had said, we will make you an offer of suitable accommodation. And therefore, the appellant was only continuing in his interim accommodation pending an offer of suitable accommodation being made.
Yes, but the point I suppose I was getting at is that your points 1 and 4 initially provided that Section 188 accommodation decision letter says this is now Section 193, but it's only pending other accommodation. Those are really your first point. Your main ground is those facts by themselves necessarily mean that it was not reasonable for him to continue to occupy.
My lord, I don't shrink from that. That is my ground.
No visitors and restricted smoking are of a slightly different character, and they perhaps do require an element of evaluation.
Yes.
But if you've won on your first point, it's really down to, if you've lost on your first point, it's really just down to whether you're going to get home on it wasn't suitable to reason for him to continue to occupy on an interim basis, because he wasn't allowed visitors and had to go outside to smoke. Well, which doesn't sound quite so appealing.
Well, my lord, what I would submit is that the entire matrix would have to be considered under the reasons head.
Yes, I see. Okay.
I mean, just pursuing that a moment longer.
Yes.
Insofar as we would be concerned with your reasons challenge, of course, no one had suggested to the officer dealing with the review that there was any problem about these points, the no visitors policy or whatever. The only point I think that had been made on reasonable to occupy was that the owner of the accommodation was biased.
Well, my lord, it is right to say that the focus of the Law Centre's submission on review was trying to argue unsuccessfully that this accommodation was protected and he couldn't just be asked to leave without making a possession order. I accept that. However, my lord, I hope to show you in due course that there were references, albeit not perhaps under the heading reasonable to continue to occupy, there were references to, well, look, this is 1881 accommodation, there's no smoking rules, he can't have visitors. I accept that was in the context of you can't take previous warnings into account, but nonetheless, the facts, the asserted facts were still present in these submissions.
Okay, thank you.
So my lord, hopefully having set up what we say this appeal is about, May I now then just make clear what this appeal is not about? We do not argue that the appellant's room could not be considered to be accommodation. Baroness Hale didn't find it necessary to go down that path in Alley in Birmingham. And my lords, in Ahmed, the recent case of Ahmed, which my Lord Justice Underhill and Lord Justice Newey will be familiar, dealt with that point. And so we, insofar as it needed to be dealt with, so we do not argue that this room should not be considered to be accommodation. We do not argue that the room has to be unsuitable. We do not need to argue that. We do not argue that the room was unsuitable for performance of the main housing duty. And the reason we don't need to argue it as a matter of law is because accommodation may be suitable for the purposes of performance of the duty, and yet not reasonable for continued occupation, so that the person remains homeless.
Yes, that last point, I know where you get it from, and it does seem counterintuitive.
Well, yes, it does. And my learned friend and I both appeared in Our Ways, and then as it became known as Alley. And certainly before Miss Justice Collins in the High Court and in the Court of Appeal, the understanding was that Section 175, subsection 3, meant that accommodation was not reasonable for continued occupation for one more night. And it was the House, the Baroness Hale, and indeed their lordships, clarified that that was an incorrect understanding of 1753.
Yeah. We'll have to look carefully at that when we get there.
Yes, we will. And I have. My lord, the third point we do not argue, just in case there's any doubt, is that an applicant can only be intentionally homeless from settled accommodation. As your lordships are aware, settled accommodation is a judge-made construct essentially designed to analyze how the chain of causation in an intentionality case may be broken. And one of the ways in which it may be broken is by the acquiring of settled accommodation. So we don't say that you can only be intentionally homeless from settled accommodation. That's looking at it the wrong way around. And we accept that you can be intentionally homeless from temporary accommodation if it can lawfully be found to be reasonable for continued occupation.
Sorry, could you just give me that phrase again? Suitable, lawfully to be found to be
Reasonable
Yes.
for continued occupation.
Yes.
That's the key question. And finally, we do not say, contrary to what may be being suggested, that a room in a hostel or a room in a house in multiple occupation can never be reasonable for continued occupation. We are concerned with the facts of this case And we say, on the facts of this case, given what had happened, the local authority erred in finding the appellant to be intentionally homeless.
And is it really your point 4? That is to say that the letter acknowledged from the start of the 193 duty kicking in that as you would say, that it was not suitable. Is that the key point? You're emphasising the facts of this case. Is that the fact you're focusing on?
That is one of the key facts, because if one thinks about that, and I'll come on to the document in a moment, but if one thinks about that Section 184 decision letter, to comply with Section 184, it has to say at the end, because of Section 184 subsection 5, it has to say you have the right to request a review of this decision. So, my lords, you will find, even if a decision is entirely positive at the 184 stage, one will always find at the end of it a paragraph which says you have a right to request a review of this decision. Although, of course, one would never request a review for a positive decision. To the ordinary homeless person reading that letter, what would they have understood from that letter? I'm slightly taking this out of turn, but they would have understood, firstly, that their main housing duty has been accepted. Secondly, they would have understood that I'm going to be made an offer of suitable accommodation. And thirdly, that I'll only get one offer, I'm not going to be made 2 offers, and it will be an offer of 1-bedroom accommodation. There would be no need to request a review of any of that. That's the best the appellant could have got. What you do have is that sentence which says, because you were formerly occupying this room under 188, and 188 comes to an end when the main housing duty is accepted, in terms of legal framework, we've now moved to 193.
Sorry, I didn't note them down properly. You said that there were 4 things you said the ordinary reader would have got from that letter. Did you have them all in your head?
You're going to come to all this.
It's our fault for taking out of course, but now you've done it. Can we just have them now? And then we'll take. No, I don't want to be taken to the letter. I just want you just helpfully tabulated what you can't.
Is that off the top of your head?
That's what comes of being such a good advocate, Mr. Newey.
I hope I'll get them in the right perhaps instead.
Your junior noted them down, I feel sure.
Don't worry.
Oh, well,
So,
don't worry.
I'll try again. So the 4 things that a person would have got is, firstly, they've accepted a main housing duty towards me.
Yeah.
Secondly, that they will make me an offer of suitable accommodation.
Yeah.
Thirdly, that I will only be made 1 offer,
Yeah.
which will be the next offer. And this is, I hope, fourthly, I'm right. And fourthly, that whilst before you were being accommodated under Section 188, because Section 188, as a matter of law, doesn't survive the acceptance of the main housing duty, the legal framework under which we now have a duty to accommodate you is 193.
I think in terms of the way you were putting it a moment ago, that was your sort of add-on point. Your 4th point might have been that it was going to be 1 bedroom.
It's going to be 1.
Was.
My lord, I'm very grateful.
Four
Yes.
wasn't spelled out, but it follows on from 1. I mean, your what you said was 4, but it's in fact 5.
Yes,
That
But-
follows on from 1.
it follows on from 1. It does, my lord, yes.
Because 4 was 1 bedroom.
And at the risk of taking you even further out of your course, at that initial stage, when, as you say, you pass from 188 to 193, but the appellant is in the halfway house, is it accepted that at that stage the halfway house was suitable for performance of the 193 duty?
Well, my lord, it is. What I say to that is, it is not accepted that it was, but it does not
It doesn't matter.
matter.
There was nothing in the letter to indicate when the offer would be made.
No, but it would be.
All it said was, you will get an offer, you'll only get 1 offer, and this is what it will be. But there was nothing about when it would be.
No. So, as my
In that sense, indefinite.
no, well, as my Lord Justice Underhill who was present in the El Kundi case, which was all about when are you in breach of duty to provide suitable accommodation. In this particular case, for example, had he not been evicted and had an offer of one-bedroom accommodation not been forthcoming, then he would have had potentially a judicial review remedy to argue breach of duty. But we don't get there because very shortly after accepting the main housing duty, he's evicted from this accommodation. The duty, my lord, I would prefer to say that rather than this accommodation being indefinite, the 193 duty is indefinite until it comes to an end under one of the prescribed routes set out in section 193.
But are you submitting, even whether or not necessarily to your case, that the 193 duty had not come to had not come to an end? I suppose that's the same as the point that my lord put to you, that it's not suitable.
Yes, so
Because if it was suitable,
yes,
that the duty would have come to an end.
not necessarily. So, for example, under section 193 subsection 5, one can be offered suitable accommodation, but the duty continues. And the reason for that is...
Remind me what 1935 is.
1935 is the main housing duty section, which said that you can perform it by providing temporary accommodation. And what the local authority can do is it can provide a series of temporary accommodations. And some might be suitable for 2 weeks, some might be suitable for...
Yes, well, that's what I understood the law to be. So, yes, I see. So the duty is only discharged by providing.
Well, not again. That used to be so that is also, my lord. So now 193 is it's got more and more complicated as time has gone on, and there are a number of routes.
Well, okay, it's my fault or our fault for going down this route. Thank you. That's been a very helpful intro. You've told us what you are arguing. You've told us what you're not arguing. Any more on by way of introduction?
No, that's why we.
Thank you.
My lord, so I would then what I propose to do, unless your lordship would like a contrary course, is to go to the law and then to go to the documents. But I'm equally happy to go to the documents first and then to go to the law.
You do whichever you prefer.
Well, my lord, then I would like to go to the law and go in particular to the Housing Act of 1996. Tab 1 of the bundle contains, unfortunately, an over-pruned part 7. But for present purposes, firstly, at page 2, tab 1 and page 2, internal numbering, we have section 175, which is really the key section because it defines homelessness. Section 175(1) is a person is homeless if no accommodation available for occupation, which are entitled to occupy by virtue of an interest or virtue of an order of a court, or if there is an expressed or implied license to occupy, or if you occupy as a residence. Section 175 subsection 3 was an amendment to the original homelessness statute. The original homelessness legislation, as your lordships will doubtless be aware, was passed in 1977. At that stage, 175 subsection 3 was not contained in the Act.
When did it come in?
It came in 1986. The history of it, my lords, again, is set out in Baroness Hale's speech in Alley and Birmingham.
Yes, okay, we needn't go there now. Yes.
And the reason, perhaps, this is surmise on my part, but one of the reasons perhaps for the introduction was the case of Pulhofer. Because in Pulhofer, the House of Lords considered whether accommodation had to be reasonable to count as accommodation, what was required. And there was the famous speech that perhaps Diogenes' barrel might not count as accommodation. But apart from that, almost anything counted as accommodation. That leads to 175 subsection 3. You're not to be treated as having accommodation unless it would be reasonable to continue to occupy. And then just by put it very briefly, I think it's fair to say, until Ali and Birmingham, that everyone assumed that meant that accommodation was reasonable to continue to occupy unless it was not reasonable to continue to occupy for one more night. That was although it doesn't appear, but in the case of Awua, which my learned friend has referred to, we're dealing with that one can be intentionally homeless from temporary accommodation. So there were a number of, how can I put this? There were a number of accepted truths that proved to be wrong as this act developed. So the first accepted truth that proved to be wrong was that it was thought that you could only perform what we call the main housing duty by the local authority providing you with permanent accommodation or a council tenancy. And in ex parte Awua, Lord Hoffman said that was incorrect. You could perform the duty by providing temporary accommodation. That caused a major rethink. And the second truth, thought of truth, which proved to be wrong, was that reasonable to continue to occupy was a stricter test than suitability. Accommodation that was not reasonable to continue to occupy could never be suitable. And Ali and Birmingham said, no, that's wrong. You can have accommodation that is not reasonable to continue to occupy, but is suitable. So pre-Ali authorities need to be approached with a degree of caution because they were premised in the sense that it wasn't argued before the courts that 1753 meant anything other than not reasonable to continue to occupy for one more night.
You're going to come in due course. I remember it's difficult to find or to where the act refers to suitability.
Yes,
Yeah, okay.
that is in the. So it refers
You keep going, yes.
in an extra bit that was.
Yeah. Well, follow the course you were following. It's very helpful so far.
Yes, I will come to that. It deals with it in section. In 206. Well, secondly then, if I may come to section 191, which is at page 7. My lord, I have here 2 copies of the extra bits that were sent yesterday. It's very unsatisfactory.
I've got a printout of the whole of part 7.
Oh, right.
So my brethren can.
Yes, well, perhaps Lord Justice Baker and I can have them.
No, it's most unsatisfactory. I can only.
No, don't worry. You've done your apologising. We're not cross anymore. We will never cross.
It's not. Actually, so having got that then.
I was reminding myself another tiresome thing though, saying I wasn't cross, is that if you get the internet thing, you get the England stuff and the Wales stuff, which you don't. This is just a confusion. Right, okay, we've got one, okay, but you were
So I'm
taking us to 191,
Well,
which we
now
have
that
got.
we have the extra bit, my lord, it might be sensible to take you to 184, which is the
Okay.
next, which is. So 184 is the gateway provision, as it were. Because this is where the authority's duty to make inquiry is triggered in a homelessness case. If the local housing authority has reason to believe that an applicant may be homeless or threatened homelessness, they shall make inquiries. That's 184 subsection 1.
Yeah,
And then 184 subsection 3, on completing their inquiries, the authority shall notify the applicant of their decision, and so far as any issue is decided against his interests, inform him of the reasons for that decision. And then 184 subsection 5, a notice under subsection 3 or 4 shall inform the applicant of his right to request a review of the decision and of the time within which such a request must be made. And that is why even positive section 184 notifications always have at the end, you may request a review of this decision, because otherwise it is believed that you haven't complied with the requirements of section 184. You wouldn't get very far on it in a challenge, but I suppose just to be apt to comply with the Act. Then, if I may take your lordship to section 191, which is page 7 of the bundle of authorities. This is a definition of intentionality at 191.1. You become homeless intentionally if you deliberately do or fail to do anything in consequence of which a person ceases to occupy accommodation which is A, available, and B, would have been reasonable for him to continue to occupy. My lord, in passing, and it's interesting that that 191 subsection 1 was present in the 1977 Act, leading to an anomaly that one had a different definition for homelessness to that of intentionality, and that was one of the things that was remarked on in Ali.
what, so the concept of reasonableness to continue to occupy originally only had a 191 context,
Yes,
but the same language was then borrowed
yes,
or reused in the definition of homelessness in 175.3.
that's right, following Pulhofer.
Because, just spelling out what you already told us, the original 175 not simply had a different definition of homelessness, it had no definition, well, sorry, I'll start again. The original 175 had no provision about the necessary standard of accommodation,
Yes,
and it all had, the work had to be done by the word itself.
so it led to this anomaly. If let's say I'm living in a barn with no hot water and no heating with children, and I go to make a homeless application, the local authority could have found, as the Act was originally drafted, you are not homeless.
Yeah.
But if I decided to leave that barn and hand back the keys and then go to the local authority, it couldn't have found that I was intentionally homeless. Well, it would have had to have considered whether that barn was reasonable for continued occupation. So there was that anomaly.
Would that really have mattered? Because the question would never have arisen if the barn was accommodation done by Pulhofer standards. The fact that you left, they could simply refuse the main housing duty on the basis you weren't homeless, and it wouldn't be necessary to look at 191 or what was
No,
the
so
equivalent of 191.
in my perhaps example, not terribly well worded, the person leaves the barn by handing back the keys and giving up all rights to it.
Yes.
So we're not in 175 5 territory.
Yes, I see.
What the
Yes.
question now is, you are homeless because you've handed back the keys. Are you intentionally homeless?
Yes, I see. Yep.
So you've got an incentive to make yourself homeless because the local authority will then have a duty to rehouse you.
Yes, I mean it would be a risky course of action to
Yes.
take, and but it did lead to anomalies. Anyway, as I say, so now we have these counterparts. Baroness Hale in Ali calls them counterparts, 1753 and 191. Well, then if I may move to section 193. So this is the highest accommodation duty that can be owed under the Act. As your lordships are aware, Part 7 contains a series of graduated duties. It's not necessary for the purpose of this appeal to address them all, but there is the interim accommodation duty under section 188, which is accommodation that's provided pending inquiry. There is the relief duty, that's a duty to take reasonable steps to help someone find accommodation under section 189B. There is the duty to the intentionally homeless. Again, it doesn't relevant, but there is an accommodation duty to the intentionally homeless under section 190, which is a very limited in time accommodation duty if people are intentionally homeless and in priority need. And then there is this duty, which is known as the main housing duty, which applies, as we see from 1931, where the housing authority is satisfied that applicant is homeless and eligible for assistance, and are not satisfied that he became homeless intentionally, and are satisfied that he has a priority need. So a number of hurdles to get over before the main housing duty is owed, and now that the homelessness relief duty has come to an end. All those points apply, then the main housing duty is owed.
Sorry, yes.
Shall I? My lord, what that duty requires is set out at 193 subsection 2, which is that unless the authority refer the application to another local housing authority, this is a local connection provision, where an authority finds that a person does satisfy the test, but doesn't have a local connection with it, and does have a local connection with another authority, then they can refer the person back to that authority. Again, that doesn't concern the court in this case. Then they shall secure that accommodation is available for occupation by the applicant. And 1933, I know this perhaps answers your question, subject to the duty until it ceases by any of the following provisions of this section. And then, unless you wish me to, I shan't go through them all, but one of the ways in which the duty can cease is 1935. That's where the local authority offers accommodation and it is refused, and the accommodation is suitable. So that could cause the duty to come to an end. And for our purposes in this appeal, it's section 1936, subsection B, shall cease to be subject to the duty under this section if the applicant becomes homeless intentionally from the accommodation made available for his occupation. So if you're not intentionally homeless, then the duty will persist.
Where does it say that it comes to an end where you are given suitable accommodation and you accept it?
So if we look at 1936, my lord,
C.
your lordship is delighted on the fact that the word suitable does not appear in section 193, and in a moment I'll explain why.
Yes.
But you will see that there are a number of different sorts of ways in which the duty can come to an end.
Yes.
So you accept an offer of accommodation under Part 6. That would effectively be council housing, or where you're nominated to accommodation. Lots of councils now don't have their own accommodation, so it'd be housing association accommodation. Or you accept an assured tenancy from a private landlord. So there are a number of ways of it coming to an end.
Yes, but the core way, I mean, if everything works, it comes to an end under 1936 C or CC.
So what everyone, well, that's too sweeping. What applicants normally prefer, in my experience, is the 1936C, which is an offer of accommodation under a council's allocation scheme, because that gives them the most.
That's the
security.
paradigm, perhaps.
That's the paradigm. But then there are, because of the shortage of housing stock, there are lots that you now, and this is why this section has got longer and longer and longer over the years, is there are a number of routes by which the duty can cease by different
Purely
types.
for my own education, when did CC come in? Surprising that there must have been something like it before, mustn't there?
So, well, I will find out the answer to when it came in,
Yes.
but the
31st of July 2002.
I'm good.
So before the 31st of July 2002, what was the analysis when a local authority, well, by the arrangement of the local authority or by self-help, someone accepts an offer of accommodation from a private landlord, common sense says at that point they cease to be homeless, and that the main housing duty therefore ought to cease. Did it? And if so, by what route did it, if the CC wasn't there?
So there would be under 1937, I believe, there was a way in which an offer of an assured short-hold tenancy could cause a duty to come to an. Well, I'm not immediately prepared to deal with this question.
No, sorry.
Presumably D, a 1936D
That applied.
would apply by if someone accepts an offer of a private tenancy of some sort or another. Probably come under D, wouldn't they?
Well, my learned friend is absolutely correct. There was the Homelessness Act in 2002, which significantly amended Section 193. So section, well.
Yeah, well, look, forgive me if the answer is, I asked this really for my own education and just to get some of these concepts clear in my mind. If the answer is complicated, it's not something which is directly relevant, and I think I don't want to distract us.
Well, my lord, I'm perfectly happy after this hearing if it would provide a short note setting out.
Let's see. Thank you. We'll take you up on that offer if, but only if we feel it'd be helpful.
Thank you. So, but essentially, this is oversimplifying it. Before 2002, there was temporary accommodation and permanent accommodation. Temporary accommodation was 1935. That's what was by way of shorthand was called 1935 accommodation. So if you refused that accommodation, the duty could end. But if you accepted it, because it was only temporary, the duty would continue. And then in terms of what was called a final offer, that was made under the old 1937, and that would normally be the allocation of secure tenancy, and accepting that would bring the duty to an end. And then there is a case, I think, called Griffiths, where the court considered what happens to the duty when you accept an offer of temporary accommodation, which then comes to an end, is the duty in suspension or does it continue? And I think, from memory, Lord Justice Mace called it dancing on the, angels dancing on the heads of a pin, that it didn't really matter in the practical scheme of things. For our purposes today, it's 1936B is what matters in this case, that the appellant has been found to be intentionally homeless from the accommodation made available for his accommodation. But of course, it's only intentional if it's reasonable for your continued occupation. Now, my lord, as you will have seen, the word suitable doesn't appear. In fact, the word suitable doesn't appear until we get section 206, which is one of the additional pages handed up just now.
Well, suitable does appear in one context. It appears in 1935.
Yes, where they're satisfied it is suitable for the where they are satisfied it's suitable for the applicant. Yes.
Okay, but anyway, you were about to take us to 206.
But in terms of the duty, which is set out in 1932, the word suitable doesn't appear in 1932.
Right.
And that is because any accommodation which is provided under Part 7, whether it's 188 interim accommodation or accommodation provided to an intentionally homeless person prior to need or under the main housing, has to be suitable. And therefore, section 206 is the section that applies to any accommodation that is provided under Part 7.
Yes. Funny way of drafting, but still.
And so, and that says that you can only discharge your housing functions by securing a number of routes, but that accommodation has to be suitable. So, my lord, I respectfully agree that it is not necessarily the most logical way of looking at it, where you have 1753 talking about reasonable to continue to occupy, and then you have to get to section 206 before the concept of suitability is introduced.
But it would not be wrong in practice to read 175. Oh, hang on. No. Okay. To read 193.
It's at page 9.
1932, as if it read, they shall secure that suitable accommodation is available.
Yes.
Because 206 necessarily means that it must be.
Yes.
Is suitable defined?
Well, it is not defined in the Act, save for section 210, which is another page. It's the last page of the extract handed in this morning. Whether it's suitable, you have to have regard to Parts 9 and 10 of the Housing Act 1985, which is slum clearance and crowding, and then Parts 1 to 4 of the Housing Act 2004. And then the Secretary of State has also.
What are parts 1? What are parts 1 to 4 of the Housing Act 2004?
So they're all to do with housing conditions and Category 1 hazards and Category 2 hazards
I see.
that might be present in the buildings, such as overcrowding, safety.
And have rules been or has Secretary issued orders or rules?
Yes.
Which, to
Yes, for example, there has been a statutory instrument that to be suitable, accommodation must be affordable, and that was introduced by statutory instrument. Then there is another homelessness suitability of accommodation order, I think 2012, which deals with when you are getting accommodation from a private landlord in certain circumstances, what particular things need to be there for that accommodation to be suitable. And it also talks about location as well, because under section 208 of the Housing Act, where a local authority accepts an accommodation duty, it should accommodate within its own district unless it's not reasonably practicable to do so. Because of the shortage of housing stock, particularly in London, lots of local authorities are accommodating people
Yes.
hundreds of miles away.
Yeah. So how these provisions that introduce requirements for suitability don't provide a comprehensive definition of it.
No,
They restrict accommodation which would otherwise be suitable by reference to these factors.
yes, and then there is the Homelessness Code of Guidance, which is statutory guidance, which tells authorities the types of things they should be looking at before deciding that accommodation is suitable.
And how do you say suitability fits into the reasonableness provision?
So it fits in what the House of Lords told us in Alley and Birmingham. The way it fits into it is this: that there can be degrees of suitability. What is suitable for the short term may not be suitable in the mid to the long term.
Yes.
When one is looking at reasonable to continue to occupy, one is looking at the mid to the long term. But when one is looking at suitability, a local authority could say, well, this accommodation is suitable performance of our duty in the short term. That would not mean that it is necessarily reasonable to continue to occupy. My Lord, I'll try to answer that question a little.
Well, I'd certainly like to. Well, you're going to take us back to that when we get to.
I'm going to take you
Just
to
a
Alley.
broad ranging shot, just to meet
Is-
the concern of the least experienced member of the
My Lord,
tribunal.
we will, in fact,
Just two points to follow up. You said statutory guidance under what provision is
it's under section 182 of the Housing Act.
okay? And then the second point was although it is clearly, as I think you accepted, the effect of section 206 is that you can read into 1932 the word suitable before the word accommodation,
Yes.
because that necessarily follows. It doesn't necessarily follow, just looking at the statute, that you need to read suitable in to 175.
No, and you shouldn't,
No.
because they are two very distinct concepts.
Suitability is not defined by.
Because suitability, sorry, I didn't mean to cut across, my lord. The point, my point, why I said that, and tell me if I've got this right, is that 206 is about the discharge of the housing function. So anything that says to the local authority, you must provide accommodation, means you must provide suitable accommodation.
Yes.
175 is not concerned with that. That's concerned with whether someone is homeless in the first place. And therefore, therefore the word suitable is not imported by section 206.
So,
You may say the case law has that effect, but the statute doesn't.
so my Lord, yes, right in my submission to say 175 is concerned with whether you are homeless in the first place, and that was certainly 1751. 1753, as understood before Alley and Birmingham, yes, are you homeless in the first place? But post Alley and Birmingham, 1753 now is not just are you homeless in the first place, but do you remain homeless even though you've been provided with suitable accommodation?
Well, yeah, what I'm trying to do at the moment is just understand what comes out of the wording of the statute. There's clearly a gloss put on it in Alley by which we are bound. But even 1753, the word suitable is not imported into by 206.
No.
Because 206 is not concerned with specifically with accommodation provided by a local authority in the discharge of its functions.
My Lord, in a way, I suppose if one were to break down the Act, the initial part of the Act from 175 to sort of 177 is a person homeless and what can be taken into account when thinking about homelessness. Then the next question is this person eligible for assistance? I.e., does their immigration status allow housing? That's section 185. Then the next question is this person in priority need? That's section 189. Then the question is this person intentionally homeless? That's section 191. If you get through all of that, then you owe the main housing duty. What is the duty? The duty is to secure accommodation unless you refer them to another authority. And then after 204, I'm leaving out the local connection referral in 198. And after 204, it's how is the duty performed? What is the quality of accommodation? And that's why 206 says it's got to be suitable. 208 says you've got to accommodate within your own district.
Yes, right. Yeah, okay, so, yeah, well, again,
Can I
once we
just
got,
ask this, pre-alley, was it always assumed that if you were provided with suitable accommodation, you would no longer be homeless?
Yes. Because, and I
Or
hope that,
yes.
I said this quite carefully, but I think the assumption was that accommodation that was not reasonable for continued occupation could never be suitable because it wasn't reasonable for your continued occupation.
And conversely, accommodation that was suitable could never not be reasonably
Yes, my lord.
suitable.
Yes. If it's suitable, then it must be by definition. It was thought that if it was suitable, it had to be reasonable for continued occupation.
So the distinction has to lie in time frame in some way.
Distinction lies in time frame, and Ali explains why it does. And perhaps, my lords, having spoken about that, unless there are any further questions I can answer on the end, we can move on to Ali. which
Yes,
I think is
thank you.
the key case. Ali is at tab 4. The bundle of authorities. Well, what I'm going to try and do, I hope, is just try to take the court to relevant passages in Ali, trying to make good my point about A, what it says, B, what the analysis of 175 was by the court, and then what conclusion that led to in that case. What is, perhaps by way of background, so there were two cases heard together, or certainly they were considered in the same judgment. Birmingham City Council and Ali, and Moran and Manchester City Council. Now, Birmingham City Council and Ali started off as I think there were 6 judicial reviews in the administrative court before Mr. Justice Collins. And what was being challenged was, it was being alleged that Birmingham were in breach of duty because having found that people were in accommodation that was not reasonable for continued occupation, they had nonetheless said to those people, well, we can leave you here until we find something that we can offer to you. And it was alleged that that was breach of the duty. At first instance, Mr. Justice Collins found that was the case. The local authority appealed to the Court of Appeal. The Court of Appeal 3-0 agreed with Mr. Justice Collins that once you'd found that accommodation was not reasonable for continued occupation, you had to find other accommodation. You couldn't then say that accommodation was suitable. And Birmingham then appealed to the House of Lords. And they
hang on just 1 second. How did the question arise Okay, this was under the current act, so the question arose under 1753.
Under 1753, yes.
Okay. Thank you. Yes.
And then Birmingham appealed again. And the House of Lords found that contrary to what everyone had believed until then, accommodation could be reasonable, could be both not reasonable for continued occupation, but could also be suitable. So Birmingham were potentially entitled to leave people in accommodation that was not reasonable for continued occupation because they said that it was suitable. It might not be suitable for very long, but there would come a point, said Baroness Hale, where they might have to move those people on to other suitable accommodation.
Well, no, that's not quite the accurate way of putting it. To suitable accommodation.
Well,
Because although it's very artificial, let's say after a year,
yes,
it's no longer reasonable for you to live in this.
yes.
So it becomes unsuitable on day 366. And you will have to move to somewhere which is suitable.
Yes.
So that represented the pragmatic decision. So careful not to interpret it. Would that be right? A pragmatic decision given the parlous state of social housing at that time?
My lord, it was a decision that enabled the court to. It was a pragmatic decision, but it was also a jurisprudential decision because it said this is what 1753 means and this is what 206 means, and everyone's had them the wrong way around. So it had a pragmatic effect, but actually yes.
Yeah, you say it has it's a decision of the House of Lords, so it clearly has a sound jurisprudential basis.
But it told us what the law had always been, and that yes, and therefore and there have been, as your lordship's aware, there have been a number of appeal cases. We haven't put them all into this bundle, discussing how these two things work together. But yes, so going back to Ali then. First of all, paragraph 9, which is at page 52.
So just so I know, you're going to take us, rather than talk about Moran now,
Oh, sorry, perhaps I should talk about Moran as
Yes.
well.
again, for my part, it's quite striking that the factual circumstances of the cases are very different.
So I'll also talk about, apologies, my lord, I should talk about Moran. So in Moran, you had Miss Moran, who lived in a council, had a council tenancy. She was a victim of domestic abuse. She had 2 children, and she fled domestic abuse and went into a refuge. And again, I'll take you to the facts in Moran in the judgment. And after about a week there, she was evicted from the refuge because of allegations of misconduct. She went to the council and applied as homeless, and she was found to be intentionally homeless because of losing the refuge accommodation. In the county court, her appeal was allowed, with the county court judge finding this is not the type of accommodation one can be intentionally homeless from. I haven't seen the county court judgment. Historically, there had been a case, ex parte Sidhu, a very early homelessness case, in which, in a judicial review, it had been said night shelters, perhaps refuges, don't count as accommodation. But that case, I think, was in 1982, before 1753 had come into being. But anyway, in Miss Moran's case, the county court found that she was not intentionally homeless because you couldn't be intentionally homeless from being evicted from a refuge. The Court of Appeal allowed Manchester's appeal. they said, no, you could find that this accommodation was reasonable for, that you could be intentionally homeless from a refuge. And the House of Lords allowed Mrs. Moran's appeal, finding, and we'll see the basis of their finding, that you could not be intentionally homeless from eviction from a refuge for whatever reason. I mean, my learned friend in her skeleton argument raises some dire acts that could be committed without a person being intentionally homeless. But as a matter of law, a person in a refuge, what they do, whatever deliberate act they do, doesn't matter for the purpose of the intentionality test, because in almost all cases, it is not accommodation that is reasonable for their continued occupation.
You say in almost all cases.
Well, I'm always anxious not to say I can't conceive of any possible situation where that might not be the case, but I can't think of one.
Meaning it would have in some way to depend on the nature of the occupation and the particular refuge.
There would have to be something really out of the ordinary for it perhaps to be argued that the alley reasoning doesn't apply. But I'm just being cautious not to lay anything in terms of absolutes, because I find whenever I do, that tends to go wrong. Well, then, if I may refer your lordships to paragraph 9. In each case, several issues have been raised, but common to both is the meaning of the phrase accommodation in which it would be reasonable for him to continue to occupy in section 1753, the 96 Act. Does this mean that a person is only homeless if it would not be reasonable for him to stay where he is for another night? Or does it incorporate some element of looking into the future so that a person may be homeless if it is not reasonable for him to expect him to stay where he is indefinitely or for the foreseeable future? That is put, I would submit, in a very broad way. The question did not arise under the homelessness legislation that was originally enacted, and some account of how that legislation has evolved is necessary to understanding how the argument has arisen. My lord, unless you wish, I shan't take you to the telling of the history of how we get here, but I'm happy to do so if it would assist. But certainly from paragraphs 10 onwards to paragraph 13, you have in my view, a very helpful history of the development of the statute. And indeed, we see at paragraph 13, at E, reference to ex parte sidu, in which the local authority had argued that a woman was not homeless because she had accommodation available to her in the refuge, and that got short shrift from Justice Hodgson, who did not regard a crisis refuge of this sort of accommodation. Perhaps one thing to note about this paragraph is that later on in her speech, Baroness Hale says she understands why Mr. Justice Hodgson had to deal with it in this way, because this was before 175 subsection 3. Yeah. But now she says the court's got another tool.
Yes, and indeed although she's cautious about, she's careful not to say anything definitive either way about accommodation, she drops a hint that sidu probably is no longer good law on accommodation.
She does. I would accept that. Then there is, if I may then take you to paragraph 19, which is at page 56. So she sets out there that the duty under section 1932 is the highest duty owed under part 7. Perhaps in answer to my Lord Justice Underhill's question, from 1996 until amendments made by the Homelessness Act 2002, that lasted for a fixed period of 2 years. Now, however, it is unlimited in time, but comes to an end in the various ways which are listed in sections 193, 5 to 8. And there are various examples, my Lord, given there as to how the duty comes to an end. Then at paragraph 20, after having referred to 1911, she says, apparent that section 1753 and 1911 are counterparts. A person is homeless, even if he has accommodation, but it would not be reasonable for him to continue to occupy it. A person becomes homeless intentionally if he is responsible for losing accommodation, which it would have been reasonable for him to continue to occupy. And then paragraph 21, the main issue in the Birmingham case is whether it was open to the council to accept that it was not reasonable for a family to continue to occupy their present home, but to accommodate them there until something appropriate for them could be found. One of the issues in the Manchester case is whether it was reasonable to expect Miss Moran to continue to occupy her place in the refuge so that she became homeless intentionally when she behaved in a way that she was evicted. So that is the main issue. And again, we see it again at paragraph 27, page 58. The issues for this house, therefore, are one, whether accommodation which is not reasonable to expect the applicant to continue to occupy can nevertheless be suitable accommodation for the purposes of the duty under section 193, subsection 2.
That's the question of Birmingham.
That
27 is under the heading Birmingham.
It is under the heading. Well, I would say that those are the issues in both. Yes, that.
I mean, the structure of
yes.
her judgment is at 27 she's identifying the issues in Birmingham.
Yes.
And at 33 she identifies the issues in Manchester.
Yes.
But the
Obviously
second
overlap. Sorry.
Yes, I mean, the second issue at paragraph 33 is very similar to the first issue at paragraph 27.
That's right. They were almost the same issues. And in terms of the Manchester case, the facts of Miss Moran's case are set out at paragraph 28 and 28 to 31. But in particular, my lords, you will see at paragraph 29 that she had 2 children, aged 3 and 2. She also had mental health problems and chronic poor coping skills. She had a secure tenancy, which she left because of domestic violence. And then she went to Women's Refuge, firstly Trafford Women's Aid and then to North Manchester Women's Aid. And she signed a license agreement, and it's important to note the license agreement was indefinite. It allowed her to stay there as long as you need it while you decide what to do. That's the first point to note. Secondly, it had some special rules. She couldn't bring men in. I mean, these are all very sensible rules. She couldn't bring any men into the refuge. She was not to have any visitors. And she was not to have contact with neighbours or disclose the nature of the building. And breach of the rules could lead to withdrawal of the licence. And then we see at paragraph 30 that very shortly after moving there, she moved on the 18th of October 2006, and on the 30th of October, she was evicted, with the police being called to remove her. And as a consequence, she is found to be intentionally homeless by the local authority. Paragraph 31, there's an appeal to the county court, and Mr. Recorder Rigby says that if reading officers fail to take into account the ex parte sidu judgment, and that he also referred to the Code of Guidance at that time, which said that women's refuges should not be regarded as reasonable to continue to occupy in the medium and longer term.
Yes, that's slightly, well, I don't mean this rudely, it's slightly weasel worded. Reasonable to continue such accommodation is the exact wording of the statute.
Yeah.
Medium and longer term is slipped in by the guidance
It slipped in
at a time at which there was certainly no case law to support it.
No.
Yeah, that came out pejoratively, but all I meant was that it was.
They were trying to.
It was, of course, it was statutory guidance, wasn't
Statutory
it?
guidance didn't have to be followed if there was case law against it. Of course, could be departed from for good reason. What the guidance was trying to do, I might venture, is to advise that if you're occupying very short-term accommodation, that shouldn't automatically lead to a decision that a person is no longer homeless. But yes, well, it's before Ali and Birmingham in the House of Lords, that guidance was not law, and no one took it to be law. And certainly the Court of Appeal didn't in this case, because although Mr. Rigby allowed the appeal, paragraph 32, on the Court of on appeal, the Court of Appeal held that City was wrong and the guidance should be reconsidered. A refuge could be accommodation which would be reasonable to continue to occupy. And that's what we get to paragraph 33, which is very similar again to the issue in the Birmingham case. Whether a woman's refuge is accommodation, and secondly, if it is accommodation, whether it would be reasonable to continue to occupy.
And just to be clear, it's not suggested that there's anything in the current guidance that helps in this case.
No. And paragraph 34, the reasonable to continue to occupy issue is dealt with first, because it provides a solution to both cases if Birmingham and Miss Moran's representatives are correct. And this is the question. Does section 1753 mean a person is only homeless if she has accommodation which it is not reasonable for her to continue to occupy another night? Or does it mean that she can be homeless if she has accommodation which is not reasonable for her to continue to occupy for as long as she would occupy it if the local authority did not intervene? The Court of Appeal in the Manchester case and the court.
So just pausing there,
Yes.
what does the local authority intervene mean?
Well, for example, in the intervention must mean the provision of accommodation.
Other accommodation.
Other accommodation.
So the picture we're supposing is the council has accepted that it owes the main housing duty. Therefore, it has a duty to provide suitable accommodation. But we assume that the current accommodation, even if it's not reasonable to continue to occupy it, is suitable.
Yes.
And as you say, the anticipated intervention must be the provision of some other accommodation.
Yes.
So in fact, the phrase indefinitely, which appears elsewhere in the judgment, is really a shorthand for if the local authority did not intervene.
As long as she would occupy for local.
Yes.
So you're very rarely going to get a case where the local authority says, I will be in a position to make you an offer in 6 months or 3 months. So you're, until the local authority makes an offer, you just don't know when when your present situation is going to end.
And in those, and that's where it is. So one had these two separate concepts running at the same time, where the person is asking, am I in suitable accommodation? Answer, yes, you are, potentially. Is my accommodation reasonable to continue to occupy? Well, that suitability can look at a very short period of time. Reasonable to continue to occupy looks at a longer period of time. So you can have yes to the suitability question and no to the reasonable to continue to occupy question.
It is a tricky thing, for as long as you would occupy it if the local authority did not intervene. I mean, it's as long as a piece of string.
Yes, but in
Which is why perhaps indefinitely isn't a bad paraphrase.
it's not. And for example, in the refuge, if one takes a refuge example, she could stay there for as long as she needed to. That is said in the. I would suggest that is the same as indefinite, or pretty near the same as indefinite. It's not. When I say indefinite, it doesn't put a. It's not putting a stop to it. It's not saying you can stay here for a month or 6 months. It's saying you can stay here for as long as you need to.
Who decides whether she needs to?
In the refuge question, well,
In the refuge example, the answer is she does.
Well, supposing she gets an order, an occupation order, and is able to move, and on one view would be able to move back into her former family home. Is she then in the position to say no? I mean, this obviously might or might not happen.
no. Well, it might be. It is possible, even in that scenario, she might not be able to move back home. For example, let's say
She
she
might not, no, but
because there were relatives or friends or.
of course. I mean, I'm just trying to. It's really up. It's always up to the individual to say whether or not they need to.
In
The refuge example.
not in every. So in terms of the Moran license, that's what I have understood it to mean, for as long as she needed to.
I mean, there may be room. Can't remember whether there's anything further said on this, but so as long as you need it while you decide what to do, maybe the while you decide what to do does carry with it some implicit time restriction.
Yes.
Yes, perhaps. But that decision could that decision itself is not time limited. You must decide what you need to do within the next so many weeks or months.
Yeah.
So we just looked at paragraph 35. And then paragraph 36, the language suggests that 1753 and 1911 are looking to the future as well as to the present. They do not say which it is reasonable for him to occupy or which it was reasonable for him to occupy. They both use the words continue to. This suggests that they are looking at occupation over time. This suggestion is reinforced by the words would be and would have been. These again suggest an element of looking to the future as well as to the present. And they contrast with section 1771, which says it is not reasonable to continue to occupy accommodation where there's a risk of violence. And paragraph 37, these linguistic reasons are reinforced by the policy of the Act. The words defined in section 175 are homeless and threatened with homelessness. The aim is to provide help to people who have lost the homes to which they're entitled and where they could be expected to stay. 1753 was introduced for a case like the Pulhoffers, who could no doubt have been expected to stay a little while longer in their cramped accommodation, but not for the length of time that they would have to stay there if the local authority, and again we have that phrase, did not intervene by the provision of accommodation. How that works is, in Birmingham,
just staying there, in terms of repetition of phrases, we also get a little while longer, both in that paragraph and in the next paragraph.
yes, we do. Again, a little while longer, although it's not defined, it is again, it is there in both paragraphs. So in the Birmingham case, this has the advantage that the council can accept that a family is homeless, even though they can actually get by where they are for a little while longer. When I, in my submissions earlier, I referred to more suitable. I think this is what I had in mind. The council can begin the hunt for more suitable accommodation for them. Otherwise, the council would have to reject the application until the family could not stay there any longer. They'd have to go into very short-term bed and breakfast accommodation. So on the facts of the appellant's case, it is perfectly respectable argument to say that that's what's happened to him. Even let's say that his, which is not accepted, let us say that his hostel accommodation was suitable. He remains homeless because the council have already told him, we're going to make you an offer of suitable accommodation. And then at paragraph 39, it has the advantage that you do not have to make repeat applications. And that's because if you go to the local authority that applies homeless, and the local authority would say, no, the accommodation is reasonable to continue to occupy, because it's only when it's not reasonable to continue to occupy for one more night that you are homeless, then you would have to make another application, perhaps a week later. And Baroness Hill says, well, in this analysis, you don't have to make those repeat applications because you remain homeless throughout.
Yeah.
Then at paragraph 41.
Isn't paragraph 40 an important, something we should look at? Because 41 begins with this then feeds into.
Yes. So
Is it?
yes. So we
In
should.
particular, the last 6 lines of however.
Yes. Well, so yes, my lord. Paragraph 40 points out that the authority's duty under section 188 to provide with temporary accommodation immediately accords with practicality. The position will often be different in the case where the family have accommodation. That's not our case. So here she's addressing the people who are, by shorthand, sometimes called the homeless at home. They have a home, but it's not reasonable for them to continue to occupy it. They might well prefer to remain where they were while their application was considered. There's a reference to Justice Collins's judgment. And then at G, however, the combination of 1881 and 2061 means the council's interim duty under section 188 is to provide suitable accommodation. If an applicant is occupying accommodation which is unreasonable for him to continue occupying even one night, it is hard to see how such accommodation could ever satisfy section 1881. So that is, section 1753 obviously includes such cases, but does not have to be limited to them. So, my lord, the point that you are making is that 1753 includes accommodation, she says, which isn't just accommodation which is not even reasonable to continue to occupy for one more night. So it's not limited in that way.
And I suppose you see the further point, I'm not sure it matters really, that even fulfilling your section 188 duty, you have to provide suitable accommodation.
Yes. Yes, so any accommodation provided
Has
has
to
to
be
be suitable. In fact, it's a lacuna as well, perhaps it's a lacuna in the act. If one wishes to challenge the suitability of 188 accommodation, one can only challenge by way of judicial review. But if you're challenging suitability of other accommodation provided under other accommodation duties, one can do it by way of statutory review and county court appeal. All accommodation has to be suitable. Then paragraph 41, this feeds into the duty in section 193. There is nothing in the Act to say a local authority cannot take the view that a person can reasonably expect to continue to occupy accommodation which is temporary, the extent to which the accommodation is physically suitable and it be reasonable for a person to continue to occupy it must be related to the time for which he has been there and is expected to stay. And he says those observations were directed to the question of when it ceases to be reasonable for a person to continue to occupy accommodation in the context of the meaning of accommodation, but they apply equally to the point at issue here. And then paragraph 42 is we effectively we have the reasoning, the conclusion of the reasoning. Given that an authority can satisfy the full housing duty by providing temporary accommodation, which of course must be followed by further accommodation as long as the duty survives, these observations clearly do not only apply to section 188. They emphasise that accommodation which may be unreasonable for a person to continue to occupy for a long period may be reasonable for him to occupy for a short period. Accordingly, there will be cases where an applicant occupies accommodation which and my lord, this is the key paragraph, and this is a key sentence in the key paragraph, which it would not be reasonable for him to continue to occupy on a relatively long-term basis, which he would have to do if the authority did not accept him as homeless, but B, it would not be unreasonable to accept him to continue to occupy for a short period while the authority investigates his application and rights, and even thereafter, while they look for accommodation to satisfy their continuing
So
section.
to paraphrase, both under section 188 and under section 193.
Yes.
But here we haven't got indefinitely or a little while longer, or if the authority doesn't intervene, we have the contrast between a long period and a short period, or a relatively long-term basis.
Yes. And that is why the 1753 answer, Baroness Hill says, applies both in the Manchester case and in the Birmingham case. In the Manchester case, this interpretation has the advantage that a woman who has lost her home because of domestic violence remains homeless even though she has a roof over her head, in the refuge. And we have been greatly assisted by submissions of Mr. Naffler, on behalf of Women's Aid Federation of England. They point out that a refuge is not simply crisis intervention for a few nights, It is a safe haven in which to find peace and support, but it is not a place to live. There are rules which are necessary for the protection of residents, but make it impossible to live a normal family life. It is a place to gather one's strength and one's thoughts and to decide what to do with one's life. Then paragraph 44, there is again a reference to ex parte Sidhu, where Mr. Hodgson, Justice Hodgson, had instinctively felt, and in the Lordship view rightly, that Parliament did not intend that a woman who had left her violent partner and found temporary shelter in a women's refuge should no longer be considered homeless. The refuge was a mere staging post. And then at paragraph 45, when Sidhu was decided, the forerunner of section 1753 had not yet been enacted. There was no tool available to the judge to enable him to decide that Miss Sidhu remained homeless, apart from deciding that the refuge was not accommodation at all. However, I'm moving on to paragraph 46. However, another tool is now available, and it is in our view, it is proper for a local authority to decide that it would not be reasonable for a person to continue to occupy the accommodation which is available to him or her, even if it is reasonable for that person to occupy it for a little while longer.
Sorry, where are you reading from?
Paragraph 46. Just below D, if it would not be reasonable for the person to continue to occupy the accommodation for as long as he or she will have to do so unless the authority take action. That doesn't mean that the Birmingham could leave families where they're indefinitely. There would come a point where they could not continue to occupy for another night, and the council would then have to act immediately. And that is because at that stage, the accommodation would no longer be suitable.
Probably. Well, why not also because at that stage it would no longer be reasonable to continue to occupy?
Well, it's always been not reasonable to continue to occupy. So you apply as homeless to
I
Birmingham.
see.
Yeah.
Yeah, yeah.
And then missing out the next sentence. There are degrees of suitability. What is suitable for occupation in the short term may not be suitable for occupation in the medium term. And what is suitable for occupation in the medium term may not be suitable for occupation in the longer term. And then we see at paragraph 48, hence Birmingham were entitled to decide that these families were homeless, even though they could stay where they were for a little while. But they were not entitled to leave them there indefinitely. There was bound to come a time when their accommodation could no longer be described as suitable in the discharge of the duty in section 193 subsection 2. And then at paragraph 52, and here we're back to the language of indefinitely. Once it is decided that it would not be reasonable for a particular woman in a refuge to continue to occupy her place there indefinitely, it becomes unnecessary to decide whether the refuge is accommodation. Women will be homeless while they are in the refuge and remain homeless when they leave. A woman who loses her place there, even because of her own conduct, does not become homeless intentionally. In other words, and this is again is a key phrase in my submission, because it would not have been reasonable for her to continue to occupy the refuge indefinitely.
Perhaps this is the place to ask you, although but you may say you're coming to it. As Roland makes the point, what about someone who is habitually disruptive and misbehaves, and is reasonably asked, therefore, to leave first one place, then another, but unless the place where they are disruptive was, if I can use this as a shorthand, long-term suitable, the local authority will always be having to house them.
So the answer to that question may be this. When a person applies as homeless, they are provided with accommodation under Section 188(1) of the Housing Act 1996. Now, there is a decision of Justice Lewis, which we can provide, which considered the question of what happens where someone either doesn't accept the 188(1) accommodation or loses it because of their conduct. Because the 188(1) duty is expressed as applying until the final decision is reached, would you then have to provide other 188(1) accommodation? And Mr. Justice Lewis, as he was, held that you didn't. Because although the duty still existed, you didn't have to perform it because a person had lost that interim accommodation.
Okay, well, let's assume that's right. That's a first instance decision, isn't
First
it?
instance decision.
And it would be useful to have that, but you then get, as it were, a largely accidental differentiation between the situation where there was someone was accommodated under an interim duty and where they were accommodated under the 193 duty, albeit somewhere temporary or short term.
Well, look, it's a hard question, and I fear I can't duck it. Let us assume, I would like to, but I don't think I can. Let us assume that Miss Moran had burnt down the refuge deliberately, and then she'd gone to apply as homeless. On Baroness Hale's, on Ali and Birmingham analysis, she could not be intentionally homeless.
Yeah.
And let's say she's provided, I mean, with respect, it is a slightly, it's an example that is so outside what is the
Well,
reality of the situation.
Well, I'm not sure it is totally. Burn down the refuge, I agree, that's a very extreme example, but it is in the nature of, I say nothing about this particular app, but many of these people, particularly those in this type of accommodation, do have problems of all different mental health problems, addictions, and are likely to be disproportionately disruptive, such that it's entirely reasonable in the interest both of the staff and of the other residents to make them go. So although burning down the refuge may be an extreme example, the kind of situation we have on the facts of this case is not at all extreme. I would thought it's quite a common situation.
Well, the answer to some extent does lie in the local authority's own hands. So, for example, in this case, where you have the Section 184 decision, which says we will make you one offer of suitable accommodation, there are cases I've seen where the decision letter says you are in this accommodation, we consider this accommodation to be suitable. And we find, and invariably, there will also be the sentence, and reasonable for your continued occupation. That is in there in the decision letter. If a person wishes to challenge that, they do it by way of statutory review. If they want to challenge the reasonable to continue to occupy bit. If they then lose that accommodation, the authority will rely on their letter, which says, we'd found that this accommodation was suitable and reasonable for your continued occupation. But those are not the facts of this case.
You say Mr. Justice Lewis's decision might provide an answer in a Section 188 context.
Yes.
But suppose you've gone beyond Section 188, you're into Section 193. The local authority has accepted it owes the main housing duty, but it thinks that in the case of somebody with the particular problems, place he should be for the moment is a halfway house.
Yeah.
And then on your case, he can burn down the halfway house. And
So what I respectfully submit is what the local authority, what do you need? Because these are very vulnerable people. What local authorities need to do is to tell these people what precisely it is that they've decided. And so if they've decided that the accommodation that they called emergency themselves is now accommodation that's going to be used to perform the 193 duty, and they've decided that it is suitable and that it is reasonable for their continued occupation, then they say so.
But on your case, they can't say that, because if they think the best place is a halfway house, you say, based on Ali, that is incapable of being a place that it's reasonable to continue to occupy.
Again, this is why in response to the answer to the question about the refuge, I said almost always. And I would use the same, my lords, you don't think I'm, again, evading the question. I'm not laying down I'm not proposing to lay down a principle that applies in 100% of cases. But I think we do have to go back to the fact of Mrs. Moran. Let us say she's been put into 5 different refuges and evicted from each one because of her conduct. On the reasoning in Ali in Birmingham, she could not be intentionally homeless from each of those refuges. I accept it's a difficult question. I accept the facts are hard, and perhaps in cases like this, they're often unattractive. I can't resolve them.
And possibly consistently with that, thinking back to Mr. Justice Lewis's type of case, we find in paragraph 54, which you haven't got to yet, an acceptance that interim accommodation under section 188 won't stop you being homeless.
No.
So in the 188 type case, you can burn down the hostel lots and lots of times, and that just is inevitably not going to render you intentionally homeless.
So it won't render you intentionally homeless. It means that you won't get any more 188 accommodation. But that's right. If accommodation that's provided under 188 can't be used to say you're no longer homeless, unless you say, we gave this to you under 188, we're now offering it to you under 193, and we find it suitable. And if you disagree with that, you have the right to request a review of that suitability decision.
How would that help?
Well, it would let the person know. Well, as I say, frequently in these letters, the sentences not only say suitable, but also say and reasonable to continue to occupy. So often in these letters, one will see both phrases. And the way that it helps is that if a person wishes to challenge that, to say, well, actually, this accommodation is not suitable. Because suitability is something that you can expressly challenge by way of statutory review under 202(1)(f) of the Act. Then it has to be considered on review, and then it has to be considered if still challenged by way of county court appeal. And if a court is persuaded that the accommodation is not suitable, then other accommodation has to be provided.
But in your case, that's not a very satisfactory answer, because although the local authority might say it's reasonable to continue to occupy, that's wrong. It's incapable of being accommodation of that kind.
I would say this type of accommodation. Well, again, I need go no further than I need to go. And I say on the facts of this case, and I need not go any further than that. A, the local authority didn't say it was suitable when they made their 184 decision. B, they said, we will be making you an offer of suitable accommodation.
Well, okay, let's wait till we get to the letter. But
Let's wait till we get to that.
if they say it's 193, that must mean that they're, I agree, it may not be perfectly worded, but it must mean that they're saying it's suitable, because they can't make a valid 203 offer without, sorry, a valid 193 offer without a decision on suitability. So the fact they may not have spelt out, that may not have used the word suitable, doesn't mean that they have not reached a conclusion on suitability.
Well, I would submit that the court should be cautious without before deciding that that's what the local authority must have done. And
Yeah. Okay. Well, let's wait till we get there.
Let's wait till we get to that.
Just remind me, where are the provisions setting the ambit of the statutory review?
Section 202.
And are they among the ones we've got?
They are now, because we have, my lord, a copy of the three.
Right,
three
thank you.
which-
They were in the original.
And they were in the original as well.
Well, let's find them in the original then for the
In the
moment.
original, 202 is at page 16. It's 2021F, which is at the top of page 17.
Yes. So if it is suitable, but is not reasonable to expect them to continue to occupy, yes, I don't know how often, when what circumstances one wish to challenge the latter element, but that has to be challenged by judicial review.
If one wished to, but actually
Yeah.
one would not get very far, because the duty under 193, and this is where one has the 175 at one end and 206 at the other end, the duty under 193 is to provide suitable accommodation. If no accommodation is provided at all, or if there's an acceptance that accommodation is unsuitable, that would be a breach of duty challenge in the administrative court.
Yes, right.
I haven't quite thought this through. What about 2021B? If you say your duty has come to an end, you've accepted the main housing duty, then you say your duty has come to an end. Can that be challenged under 2021B?
Yes, it can. So there is, again, there's court appeal
So
authority.
this is one little b, not one b.
I have in mind one little b.
Yes, again, I think that was one of the earlier cases under the Housing Act, where the court appeal held that a decision of a local housing authority as to what duty is owed includes a decision that no duty is owed.
So if you conclude that the person has become intentionally homeless and therefore your 193 duty is at an end, it could be challenged by appeal.
Yes, it could, as could an intentionality finding, because and the way that that would be challenged is that there is a duty owed to intentionally homeless people, and so you would say, well, I challenge that because I'm not intentionally homeless.
Thank you.
Have you finished with Ali?
Well, I'm just checking. No, so there's a point. I took your lordship paragraph 43, but there is a point that I would just wish to make on paragraph 43 at page 61, which is that paragraph 43 is not special pleading for a refuge. It doesn't put refuges in a special category. It is the application of the 1753 principle. And we see that in the first sentence. This interpretation has the advantage that. And then the final paragraph, I wish to refer your lordship's paragraph 66 at page 67.
Just to note in passing, the paragraph where it is hinted that Sidhu probably isn't good law anymore is 56.
Yes.
Sorry, you're taking us to
I'm taking to paragraphs 65 and 66, because I think 65 addresses a question that your lordship put. 65 says, we would allow the appeal in a Manchester case. There may be circumstances in which it is reasonable to continue to occupy a place in refuge indefinitely. There is nothing to suggest that it was so in this case. So that gives just that little a little latitude. So it doesn't apply to all refugees for all time in every case.
So how does that relate back to the terms of the licence, which I've currently lost? This is paragraph 29.
Paragraph 29 at page
So,
58.
the licence allowed her to stay as long as you need it while you decide what to do, but that didn't make it reasonable to continue to occupy
That's right.
indefinitely.
So again, I would respect to say the court is reluctant to lay down a principle that can never ever be that applies in every single case. That's just, but yes, arguably, the license set out in paragraph 29 is in fairly indefinite terms. Although, as your lordship said, there may come a time where either the refuge or Miss Moran could have decided, I no longer need to be here. And then paragraph 66. So this is the declaration that is made. It is lawful for the council to decide that a family is homeless because it is not reasonable for the family to remain in their present accommodation indefinitely and to accommodate them there for as long as it is suitable as short-term accommodation. So again, the word indefinitely is used again there. Well, that is my, those are my submissions in respect of Ali. I'm now just hopefully, with much more speed, take your lordships to 4 more authorities, very briefly, which have addressed Ali and just do forgive me for a moment. Firstly, my lord, at tab 5, we have the case of CN and Lewisham, a decision of the Supreme Court. This case concerned whether accommodation provided under section 1881 of the Housing Act attracted the protection of the Protection from Eviction Act, so that you could not be evicted without notice being given under section 5 of the Act, and an order for possession being obtained from the court. And in a majority decision, the Supreme Court decided that you did not have to give a written notice for such accommodation, and you did not have to obtain a court order. One of the issues that the court considered was, when is accommodation occupied as a dwelling? Now, that is not the same question as the word dwelling doesn't appear in 193, which deals with accommodation. But nonetheless, Moran is referred to in this judgment at paragraph 33, which is at page 86. It may just be helpful to look at that. So looking at these 1881 licenses, my lord, if I may just pause to make this point, there is no doubt that the license given to Mr. Kyle in our appeal was a 1881 license. He was not provided with any license, any discrete license, after acceptance of the main housing duty. So,
Sorry, a 1881 license, did you say?
yes.
Is there such a thing?
So, in the sense that it was a license, the authority have not been able to produce the written license, although we've asked for it. But he would have been given a license to occupy his room. He must have been, and it must have been under section 1881.
Just
When you say
because-
under, what do you mean? I mean, a license is a license.
When I say under, I mean as a result of operation, as a result of the operation of section 1881.
But it wouldn't have been granted by the local authority, would it?
No, it wouldn't have been granted by the local authority. It would have been that is the way that the local authority were performing their 1881 duty.
But in that sense, I mean, it's a license granted by the owner of the property,
Yes.
and the license just endures whatever duties are going on in the background.
My lord, you're up. That's right. I'm grateful. But in terms of whether such a license is licensed to occupy premises of dwelling, and in an illusion, this was a license for a 5-bedroom house. Again, I think from a page we see this license. Yes, we see at paragraphs 2 at page 77 that became homeless in November, applied as homeless, granted a license, a 5-bedroom house with communal kitchen and bathroom, pending inquiries, and that property was privately owned. Its owner licensed it to Lewisham for use as temporary accommodation for homeless persons. Going back to paragraph 33. George Hodge said there's a number of features that militate against such licenses to occupy premises of dwelling. First, there is a statutory context of the license of the 96 Act, namely the provision by the local housing authority to a homeless person of short-term accommodation. That is what we have in this case. Then just above C, the statutory duty in section 188 is to secure accommodation for the applicant, not set necessarily at one location for a short indeterminate period. Most significantly, a person who is given temporary accommodation under Part 7, may only be 188 accommodation, I suspect, does not cease to be homeless. To hold otherwise would defeat the scheme of the 96 Act. But then moving on from there's also been refuge to the said to be an analogous principle that in most cases a woman who is left at home because of domestic or other violence within it remains homeless even if she has found temporary haven in a women's refuge. Such temporary accommodation is not intended to provide a home. Another way of looking at the matter is that having a roof over your head in such short-term accommodation does not give you a fixed abode. There is.
Sorry, are you moving on from this
I am.
case? Just, I don't think it matters for our purposes, but when you come to 45, when Lord Hodge is sort of summing up, at 4, he says, under the 1996 Act, a person remains homeless while he or she occupies temporary accommodation provided under, and then the first section he lists is 1883.
Yes.
Why,
Doesn't-
why 1883, not 1881?
I don't know. These are all duties which fall short of the main housing duty.
But the 1883 duty is just pending review. Isn't it?
So it's a discretion. It's not even a duty.
Yes.
Yes.
So whereas earlier on he seems to say, well, if you're in 188 at all, you're homeless. Here you seem to be homeless if it's pending review.
Yes. Or if you're 192 is a duty accommodation due to the intentionally homeless. And 200 subsection 1 is when you're, I think, accommodated whilst there's a dispute going on as to whether you have local connection with a local authority or not.
Yeah.
But again, paragraph 45, and it's at H, doesn't show any intention to allow the homeless applicant to make his or her home in the accommodation. And that, I say, is important in our case when one looks at the 184 decision. Well, look, may I move on from that authority list? So Ali and Birmingham was considered at length by Lord Justice Lewis and Lord Justice Underhill in El Kundi and Birmingham, which is at tab 10. And I need not take your lordships to much of this decision, apart from paragraph 101, which is at page 218. Where having gone through Ali and Birmingham, Lord Justice Lewis says, analysing the speech, the basis for Baroness Hill's decision for allowing the appeal is that a person may be homeless for the purpose of section 175 if he is in accommodation which it is reasonable for him to occupy at present, albeit that at some stage in the future it will cease to be reasonable to continue to occupy. Given that the local housing authority would not necessarily be in breach of section 1932 by leaving a person who is homeless in his present accommodation, the reason is that it may become unreasonable for him to continue to occupy that accommodation in the medium or longer term, but it is not necessarily unreasonable for him to occupy the accommodation at present. So they're making again the distinction between suitability and reasonable to continue to occupy. And at paragraph 102, Lord Justice Lewis says that, in my judgment, is the ratio decidendi of the decision. And again, we have the phrase there at F at 101 when one's looking at the medium or longer term. And then, my lords, we have two cases this year. Firstly, the case of Hodge and Folkestone, which is at tab 11. Which in my submission doesn't assist very much in this case. I hope to explain why. So in this case, in Hodge and Folkestone, the applicant left a room in a hostel and she was found to be intentionally homeless. And the issue on appeal, we see that at paragraph 3, the question on this appeal is what constitutes accommodation for the purposes of section 191 subsection 1. That is not the issue on this appeal. As I said right at the beginning, this is not an appeal about whether the room was accommodation. It concerns whether it was reasonable for continued occupation. We see at paragraph 16, page 239, that in accordance with the question to be determined, the authorities referred to were Pulhofer, Rower, and Birmingham City Council and Ali. At paragraph 42, this is what I'd say this case actually is not very helpful at all. We see the last two sentences of paragraph 42, what had been argued was that because the room was only provided temporarily, it could not be regarded as settled accommodation, and so you could not be intentionally homeless from that accommodation. That was the argument by the her reference. Now, we do not argue that the room had to be settled accommodation before Mr. Kyle could be intentionally homeless from it. We picked that up again at paragraph 60 at the top of page 248. Where we see Lord Justice Arnold gave permission to be on two issues. Was the room accommodation, and did it have to be settled accommodation or not? And then paragraph 63 appears to be a misunderstanding in my submission by the applicant's representatives of what Ali and Birmingham had decided. Because we see about halfway down, Mr. Colville, who appeared for the homeless applicant, submitted that temporary accommodation, such as a room, is not accommodation for the purpose of section 1911. It is like a refuge. Well, that was precisely the question that Baroness Hale did not feel the need to deal with in Ali and Birmingham. And the decision is at paragraph 73 at page 250, where it is found halfway down that paragraph, contrary to Mr. Colwell's submissions, Ali does not decide that a woman's refuge or similar habitation is not accommodation. Finally, authority which binds this court decides that in order to qualify as accommodation for the purpose of Part 7, there is no requirement that accommodation be settled. And again, the risk of repeating myself, we don't argue he wasn't an accommodation. We don't argue that his accommodation had to be settled before it qualified as accommodation.
What about the last sentence of paragraph 77?
So in that case, she'd been there a year. The council were entitled to find it was reasonable to continue to occupy. There she's in accommodation for a year and leaves. In our case, he is in accommodation, is provided with a letter saying we accept a duty towards you, you will be made an offer of suitable accommodation. And then, my lord, the case of Ahmed and Haringey, in which my lord, Lord Justice Newey and Lord Justice Underhill gave judgment, along with the Master of the Rolls. Now, my lord, at the risk of making submissions on a case in which you may, this was a case which concerned a half-board room. And it was argued that it wasn't suitable accommodation and not reasonable for continued occupation. And so Miss Ahmed was homeless. And we see that at paragraph 2, my Lord Justice Newey's judgment, page 254. So there it is said, not suitable. And we find it paragraph 9, factually this case is very different from ours, that this room, paragraph 8, apologies, so this room in a hostel was single occupancy. She is told by the officer this is not temporary accommodation. She's told that it's not supported, and that the hostel provided a license agreement rather than a short tenancy. So it is expressed in indefinite terms. And then at paragraph 9, the housing officer informed Ms. Mohammed that you had accommodation available for at least 6 months, which was suitable. and the homelessness relief duty had come to an end. And this court found that the homelessness relief duty had come to an end and that she was no longer homeless. That was the ratio of the decision. It wasn't a case that looked at 193 subsection 2 and its interaction with section 1753 and section 206. And we see at paragraph 22 that there was a fairly narrow issue for which permission to appeal was given. Permission was granted by Lord Justice Snowden on a single ground to the effect that Judge Ward had been wrong to consider that supposing the relief duty had come to an end by reason of the provision of suitable accommodation, that also meant that Miss Hamid was not homeless and so not owed the main housing duty.
But we also had the county court appeal.
My apologies.
We had that appeal, but then if you look on, there'd been a review and an appeal to the county court, and Judge Luber had given permission to appeal from the county court.
So Judge Luber had transferred it to.
Yeah, you're quite right. He hadn't given. Yeah, yes, you're exactly right. Yes.
And then after setting out the legal regime, at paragraph 38, under the heading the issues, we have a letter, 14th of December, satisfied, suitable and reasonable to continue to occupy. Relief duty had come to an end, and Miss Hamid was not homeless and so could not be owed the main housing duty. The dispute, at paragraph 39, it was contended it wasn't suitable, and also that it was not reasonable to continue to occupy, so she remained homeless. And Mr. Evans, who appeared for the council, paragraph 40, he said that section 193 did not apply since Miss Mohammed was not homeless. At paragraph 46, paragraph 46 to 48, my lords, that perhaps may be of particular relevance here. My Lord Justice Newey stated, I would not exclude the possibility of a person being homeless and so owe the main housing duty under section 193, despite having suitable accommodation available for occupation and a reasonable prospect of retaining it for at least 6 months. The fact, however, that section 189B7A requires a reasonable prospect of having suitable accommodation available for at least 6 months makes that scenario much less likely. Typically, the matters rendering the accommodation potentially suitable for at least 6 months will also tend to make it such that it would be reasonable to continue to occupy. But the key point is you could have accommodation which is suitable and available for at least 6 months, and yet that accommodation not be reasonable for continued occupation. Then at paragraph 47, there is the analysis of what Baroness Hale meant by indefinitely. And 4 lines down, Baroness Hale's concern, reflecting section 1753, was whether a person could be expected to put up with accommodation indefinitely. And then she was not suggesting that for it to be reasonable for a person to continue to occupy accommodation, the person had to be able to stay there indefinitely, or even for any particular period of time. In my submission, she does speak about time because she talks about the mid-term to the long term in her decision, in her speech. But she does not say, she doesn't specify more than that. as to what is meant by mid-term or long-term or indefinite. And then at paragraph 48, the court accepts that accommodation at the hostel secured, if it's secured in section 188, is less likely to satisfy section 1753.
Can I just think about this?
Yes.
So suppose you're in accommodation, luxury accommodation, and have a tenancy that's going to last another 3 months.
Yes.
Are you homeless?
You may very well be, in the sense that, let's say, well, see, one could put in all sorts of factors. Let's say I'm in luxury accommodation, but it is in a location where I am concerned.
Assume it's in a marvellous
Perfect.
location. A luxury accommodation in a marvellous luxury accommodation in a marvellous location,
Yeah.
and indeed your tenancy originally was a 3-year tenancy, but you have 3 months left.
Yeah.
So you can't stay there indefinitely.
Yeah.
You've got 3 months. Are you already homeless?
Yes, well, my lord, may I make, if I could just, instead of 3 months, if I might make it 2 months. So a short hold tenancies require 2 months' notice to be given under Section 21 of the Housing Act 1988. And the Code of Guidance tells local authorities that if someone's received a Section 21 notice, which requires them to leave in 2 months, they should be accepting those people as homeless.
But, well, 2 things. First of all, 1754 says you're threatened with homelessness if you're likely to become homeless within 56 days.
Yes.
So if you've got a 3-month tenancy, you're not, on the face of it, threatened with homelessness. But on the other hand, you can't stay there indefinitely.
Yeah.
So if we take seriously what Baroness Hale has said in the way you might suggest that she said it, you're homeless already because you can't stay there forever.
Well, my lord, I appeared for the losing party in the House of Lords in Birmingham City Council Alley, and one of the submissions we made was that Section 1753 had to be the not one more night formulation, because otherwise, how did it sit with the threatened with homelessness provision? So it's not that that submission wasn't made, but it having been made, the House of Lords decided that it didn't affect the 1753 analysis.
And I see that, so I'm throwing in the 56 days perhaps unnecessarily, but it makes no sense, does it, to say that someone who is 3 months off the end of a tenancy in really good accommodation in a really good location is homeless, even though they can't stay there indefinitely.
Well, my lord, I think I can do no more than
Well, presumably, if they're to be reconciled, it's got to be that what Lady Hale had in mind was that the property was substandard, and the real concept of the indefinitely was having to put up with substandard accommodation for the medium or long term.
Well, not necessarily, because there was no suggestion that the refuge of itself was substandard.
Well, well, I don't mean substandard for a refuge, it was substandard for a home.
Yes, substandard for a home. Yes, my lord, I in the sense that it is not, going back to the CN and Lewisham dwelling point, it is not something that you could consider to be your home.
Well, I'm just trying to find a way of reconciling my lord's example with the ratio of alley. That would seem to be on the face of it the obvious reconciliation. I mean, alley was concerned with somewhere which was whether, assuming that it was in fact accommodation,
Yes,
had a number of difficulties about it,
yes,
which my lord's example is this is the perfect
yes.
accommodation.
No, my lord, yes, in Alley and Birmingham, all 6 of the claimants either were in accommodation that was overcrowded or were in accommodation that was in
Yeah.
disrepair.
I mean, the whole concept is putting up with it for a short time, which suggests there's something to put up with. Anyway, sorry, I'm taking over, my lords.
My lord,
I see the time. Were you going to say had you anything more to say about Hamid?
my lord,
I think my lord said you had two points, or are they both? Maybe I misheard.
If I did, the second one has evaporated. I can't remember what it would have been.
Subsumed. Well, very well.
well, just one point to make on Hamid was that ultimately Hamid was decided on the facts of that case.
Okay. Now, how much longer are you going to be after the adjournment? You've got to take us to the documents. You've got to make your submissions, although you've largely done so, as often happens. So, well, how long do you think you're likely to be?
I don't, no longer than 30 minutes. If that's too much, then I can speak more quickly and edit.
So your pacing is, if I may say so, admirable. I wouldn't want you to do that, but I think obviously, Miss Rowland inevitably should be much shorter because we've been over much of the ground. Does it create difficulties for you if he's 30 minutes?
No, not at all, my lord.
No, I wouldn't have thought so, but if you can be less than 30 minutes, that's always welcome.
Of course.
You shouldn't be more.
I may very well be less.
Very well. 2 o'clock.
All right.
Excuse me.